court now calls the case of Kenneth Failen, 26M23. Mr. Failen, if you want to come forward. Mr. Failen is here in person in the courtroom. Thank you for being here today. Mr. Shield is here in person on behalf of the prosecution. I'll find good cause, or I don't need to find good cause. Mr. Failen, did you understand the rights that you have that I explained earlier?
I'm here under a threatened arrest from the state of Colorado, and I retain all of my rights.
Okay, so I'm assuming since you're retaining your rights that you understand what your rights are, correct? All right. In your case, you're charged with a petty offense of third degree petty offense. A petty offense of third degree trespass. If you were to plead guilty or be found guilty of this offense, you could be ordered to serve up to 10 days in jail and pay a fine of up to $300. Do you understand the charge that you are accused of?
No.
What about that charge do you not understand?
To the U.S. Constitution, I'm allowed to go into, well, I have a right to petition the government, and so I don't understand how this charge is lawful.
Okay, well, you're accused of this. Nobody's finding you guilty. If you believe that you have a legal defense, you can say that you're not guilty and request a trial and require that the prosecution prove the charge beyond a reasonable doubt before you could be convicted or found guilty. But right now, I'm just telling you what you're accused of. Do you understand what you're accused of?
Not guilty.
Okay. That's not, you're moving steps ahead before my question is, do you understand what you're accused of?
No.
What about the accusation do you not understand? I understand that you think you're not guilty, but in order to think you're not guilty, you have to understand the accusation. By saying that you're not guilty, that implies that you understand what you're accused of, because you couldn't say that you're not guilty if you didn't understand it. So do you understand what you're accused of?
I am in standing of being that this charge is frivolous and malicious.
Okay, so you can plead not guilty and seek to require that the district attorney prove the charge beyond a reasonable doubt and that the charge isn't frivolous or malicious, which isn't a defense, by the way. I am going to interpret your response as you understand what you're accused of, because you're telling me that you're not guilty of it and that the charge is frivolous and malicious. You couldn't say that the charge was that you think it's frivolous or malicious if you didn't understand what it was. So I'm interpreting your response to mean that you understand what you're accused of. The next step in this process is I have to issue a thing called a mandatory protection order. So at this time, I'm ordering that you may not harass, molest, intimidate, retaliate against, or tamper with any of the people who are witnesses or victims of the act that you are alleged to have committed. Okay?
And I still have the right to face my accuser, is that correct?
You do. You're not allowed to harass, molest, intimidate, retaliate against, or tamper with them, though.
So in the state, so the U.S. Constitution says that the state is not allowed to charge a citizen without the jurisdiction of the Supreme Court. And this, and I understand that this is the state of Colorado charging a person of the United States. And so Uh, and so the jurisdiction is led to the Supreme Court and
So
I do not.
You're
know
not
that-
making
I
sense.
don't think
The
that
court
there's any
has
witnesses.
jurisdiction.
I don't believe there's any witnesses, or can we?
You might think that there's no witnesses, and there might be no witnesses, but if there are, you can't harass, molest, intimidate, or retaliate against them.
And
Okay.
can we set a date for discovery or?
So if you need information about how to get the discovery in the case, you would need to contact the office of the district attorney. I don't have any discovery in the case. I have no police reports. I don't get any of that. If you want any of that information, you have to get it from the district attorney's office. I believe that they have a form that you have to fill out that tells them where you want them to send that information, and then they'll send it to you. Okay? So right now, you can't harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you're alleged to have committed. This is a condition of your bond, and if you were to be suspected of violating this order, you could face additional criminal charges. So in a moment, my clerk's going to have a copy of that protection order. She's going to ask you to sign it and acknowledge that we're giving you a copy of it. And you can take a copy of it with you. If you have questions about what that order says, you will have a copy and you can read it as many times as you want to, or go over it with the help of an attorney, okay? So in a moment, my clerk will give you that. In this case, you have the right to have the help of an attorney. Are you planning on hiring an attorney or applying at the public defender to see if you qualify for a free attorney?
I am I'm appearing as a special appearance today, and
You're not appearing as a special appearance. You're appearing as Kenneth Failen here and standing in front of me in the courtroom. A special appearance is when you're an attorney.
Kenneth Failen.
Mr. Failen, if you want me to find that you're not Mr. Failen, then I'll issue a warrant for your arrest for failing to appear. Do you want me to do that?
Well, that's what happened last time, but I don't.
Last time you didn't appear in court, so I issued a warrant for your arrest. So if you want me to make a finding that you're not stating that you're Kenneth Failen, then I'll find that you failed to appear and I'll issue another warrant for failing to appear. So
No,
I'm going to,
don't do that, please.
Well, then stop playing your stupid ass games before you win another stupid ass prize.
okay. So you have the right to have an attorney. You're not making a special appearance. A special appearance is when an attorney appears without representing somebody to do something small in a case. As far as I know, you're not a licensed attorney. You're not representing yourself as an attorney. If you want to represent yourself not as an attorney, you're free to do that. But if you want to get an attorney's help on this case, I'm willing to give you time to do that. Would you like time to get an attorney's help on this case?
No.
All right. Are you going to be representing yourself without an attorney?
To jurists.
That's not a response. It's a yes or no question. Are you going to be representing yourself without an attorney?
I will retain all my rights as a person of the
All right.
United States.
Do you want to plead not guilty at this time and set your matter for trial?
Not guilty.
All right. We're going to go ahead and set this matter for a trial. I have an advisement that I need to give you because you're setting the case for trial without the help of an attorney. So I have a series of questions that I have to ask you. Do you understand that you have the right to be represented by an attorney throughout these proceedings?
So it's this. I mean, I'm being present in court. It's the state has like
It's a yes or no question. You told me that you were
Do I-
exercising all your rights. One of your rights is the right to have an attorney. Do you understand that? Yes or no?
No.
What don't you understand about your right to have an attorney?
How I am, the, so why this, this charge as has like brought me, it's, what am I? So, an attorney, has to be, so if I want an attorney, then I am, there's, I am somebody else in the case that, like, it would be, I just don't understand it, I guess.
Yeah, no shit. That's what happens when you get all of your information from other idiots on the internet. And now you're about to earn yourself a competency exam.
All right, Mr. Phelan, are you under the influence of any controlled substances today?
Nope.
It appears to me that you are having difficulty formulating thoughts or expressing yourself in complete sentences. I'm concerned about your competency. So at this time, I am going to raise competency for Mr. Phelan. When a court raises competency because they are concerned that you are not competent in this case, that means that I believe that you're suffering from some sort of impairment of thought that allows you to understand these proceedings and participate in the proceedings. So the state of Colorado has to have an evaluation done of you by a doctor who is trained in impairments of the mental condition. And then that doctor conducts an evaluation and writes a report and tells the court what their medical opinion is of whether or not you are competent to proceed. So I'm going to issue an order that
I do not consent.
it's not something that you consent to. When I think that somebody's not competent,
So you give
I
a
am,
doctor a voice, not a person.
when I think that somebody is not competent, I am legally required to order a competency evaluation or make a finding that they're not competent and order that they participate in proceedings related to restoration to competency. It's not something I have a choice over. It's something that I'm legally required to do.
You have
And based on your
the damages that you have caused me.
inability to formulate complete sentences or express,
This court has caused extreme damage for the past 2 years. I'm here under threat and duress. So that's all I have to say.
all right, so I am raising competency with regard to Mr. Phelan. My clerk of court is going to prepare an order to the Office of Behavioral Health directing that they appoint a medical doctor to conduct a competency evaluation. I'm also going to appoint a Bridges Court liaison. Right now, I don't know who the Bridges Court liaison is going to be because our normal Bridges Court liaison is on an undetermined duration of leave. And we have other Bridges Court liaisons from other parts of the state covering for her. But I need to provide the Bridges Court liaison with your contact information so they can get in touch with you. They will be coordinating with you when the evaluation will be completed as well as any other services that you might want to have them help you with. On your bond paperwork, you listed a phone number of 541-848-7484. Is that your current phone number?
Don't, I don't use a phone number anymore.
All right, we need to have a way for these people to get in touch with you. Do you have an email address?
They can meet me in person.
Well, they need
They better
to
not
have
come
a
on
way
my
to,
private property.
they need to have a way to get in touch with you so they can make an appointment with you to meet you in person.
Well, I'm gonna stay out on my private property and they ain't gonna reach me.
What's your private property address?
Oh,
All right, Mr. Failen, it looks like the summons lists an address on State Highway 131. I'm going to have you return to court.
I moved.
Okay, I'm going to have you return to court on Friday morning, and I'm going to have the Bridges Court liaison here so that the Bridges Court liaison can speak to you directly about making an appointment with you. So I'll ask that you please appear on March 27th. That's this coming Friday at 9 o'clock in the morning. You can appear virtually or in person. I'll have the Bridges Court liaison here, and the Bridges Court liaison will talk to you directly about setting up a time to get in touch with you and meet with you, and setting up the evaluation. Okay.
The 29th.
March 27th, that's this coming Friday
Okay.
at 9 o'clock in the morning. I'll ask that my clerk of court please indicate on the Bridges order the next day and time of the court hearing, and that Mr. Failen will be available at that hearing for the Bridges Court liaison to get his contact information. All right, Mr. Failen, you are free now to leave the courtroom, and I'll see you next either virtually or in person on March 27th at 9 o'clock in the morning.
Thank you.
Mr. Failen, we do need you to sign that protection order, and then my clerk will make a copy for you.
I'm not signing it.
All right, if you refuse to sign it, you've still been advised of it. My clerk will write that you refuse to sign it, and if you want to get a copy of it, she can make a copy for you. But you have been advised on the record. My clerk will note on the form that you've been advised on the record, you've acknowledged the protection order on the record, and that you refuse to sign it. If you want a copy of it, you need to wait here so she can make a copy for you. For the record, Mr. Failen has exited the courtroom. He has refused to sign the mandatory protection order, but he was advised of the protection order